My name is Claire Gamage. I'm a legal director at TLT, and in this bite-sized session, I'm going to talk through the changes which the new Procurement Act 2023 introduces in respect of KPIs, poor performance and payments. So I'm a specialist in public procurement law, having spent almost 11 years acting for public sector bodies, but also the private sector suppliers in terms of supporting formal and informal challenges and also advising those participating in high value or complex procurement processes. The session will focus on the 5 topics listed here, so namely the rules which contracting authorities must follow in terms of setting and monitoring KPIs, poor performance, payments and invoicing. We're then going to look at some of the key provisions in public contracts which we would recommend that you check when you're bidding for public contracts. And finally, we're going to run through what we believe are some of the key takeaways in these particular areas. So from the perspective of your contracting authority customers, there are certain rules that they will need to follow, and it's important to have an understanding of those, as this does represent quite a fundamental change compared with the existing regime. Much more information will be available within the public domain, including about your performance of the contract. So firstly, if the contract value exceeds 5 million, the authority must set at least 3 KPIs. Now, all of the KPIs set, so if there's more than 3, all of them must be published on the new central digital platform. Now, in terms of how this information will be published, firstly, the authority is obliged to publish a full copy of the contract following signature. Therefore, the obligation to publish all of those KPIs is essentially discharged by publishing the contract documents. Secondly, the authority must publish what's called a contract details notice after the contract is signed. And in that notice, the authority must set out what it believes to be the 3 KPIs which it regards as the most material to the performance of the contract obligations at that time when the notice is published. Thereafter, performance against those KPIs will be published annually and on termination of the contract, and that will be published in something called a contract performance notice. Now, a particular thing to note here is that at the time that the contract performance notice is published, the authority might have changed its mind in terms of what it considers to be the most material to the performance of the contract obligations. So those KPIs which are monitored and published annually, they may change year on year. Now, there are some exceptions to these rules, however. So firstly, if the authority considers that the supplier's performance could not be appropriately assessed by reference to KPIs, then there's no requirement to comply with the rules that I've just referred to. Secondly, the rules will not apply to framework agreements. So if you're dealing with customers via framework agreements, the KPIs in the framework will not be monitored in this way. However, they will apply to call-off contracts awarded under the framework if the value of that call-off exceeds 5 million. And finally, the rules will not apply at all to utilities contracts awarded by private utilities. They don't apply to concession contracts, and they won't apply to light touch contracts. There will be some standardisation required in order to ensure that the data on performance can be collected in a consistent manner. So in terms of the performance measures themselves, they will differ from contract to contract. For example, what an authority determines what good looks like in an IT contract is likely to be quite different to a construction contract. And likewise, the frequency of when those measurements are taken could be different. So they could be annual, quarterly, monthly, and so on and so forth. But the ratings that need to be applied against each performance measure must adopt the standard approach, which is outlined on the slide there. It will be for the authorities to determine the exact detail in terms of what percentages or measurements are aligned to a good and approaching target, etc. But those standard ratings will be used across the board. So in terms of poor performance, firstly, it's important to note that the Act doesn't oblige contracting authorities to terminate a contract for poor performance, which I'm sure is welcome news. However, poor performance in a public contract could have an impact where you are bidding for other contracts. And this is because contracting authorities have a discretion whether to exclude a supplier if any of the three circumstances apply, which are outlined on the slide there. So just looking at those three bullets in particular, the first one, where a supplier has breached a public contract and the breach is sufficiently serious. And there is a definition of sufficiently serious in the Act, which I've included there on the slide. This is perhaps of particular importance in respect of construction contracts, as the definition refers to the award of damages, so a breach followed by the award of damages. And I'll come back to this a little bit later, but you think about liquidated damages, which are quite common in construction contracts. I mean, these could ostensibly be considered damages and therefore a sufficiently serious breach. Secondly, where a supplier has not performed a public contract to an authority's satisfaction, where it was given a proper opportunity to do so, but failed, therefore failing to implement actions agreed in a rectification plan, for example, this could conceivably trigger this particular ground. Now, looking at the third ground, if any of the above circumstances have occurred and the authority has published information about this in either a contract performance notice or a contract termination notice, and that notice expressly refers to section 71(5) of the Act, this third ground could be triggered. Finally, there will be an implied right to terminate a public contract if the supplier has, since the award of the contract, become an excludable supplier. And that means if one of the three circumstances referred to above arise, the contracting authority could decide to exercise this implied right to terminate the contract. So it's pretty serious. Therefore, it would be incredibly important that the contract is clear in terms of setting out what would happen if the authority decided to terminate on this basis, particularly when thinking about things like liability, costs for each party. So just to make sure your contract accommodates that particular scenario. So in terms of payment, the rules concerning payment do not bring about fundamental changes, and things are pretty much the same in that valid and undisputed invoices must be paid within 30 days, and that applies throughout the supply chain. So subcontractors also must be paid within 30 days. Now, an invoice is considered valid if it's supplied in the required electronic form, if it sets out the minimum information required, which is listed on the slide there, and it meets any other contractual requirement. Therefore, it's going to be extremely important to check what your public sector customers' invoices requirements are in the contract, and that you raise those invoices strictly in accordance with those conditions in order to ensure that payment is made within 30 days. Now, a key change to the rules here is that an authority must now publish what's called a payments compliance notice every 6 months, and that notice will detail its adherence to these 30-day payment rules. And there are some limited exceptions to these requirements as set out on the slides there. So concessions, utilities contracts awarded by a private utility, or contracts awarded by a school. Given the scope of these changes, our recommendation is that suppliers, contractors become more proactive now in terms of checking what's included within a public contract, and equally looking for what's not included, because some things might be missing at the earliest possible stage in the competition. And don't assume that you'll be in a position to negotiate these terms if you are the successful bidder. This can give rise to significant procurement law issues for the authority if you attempt to negotiate it in later stages of the competition. Therefore, use any opportunity you have to engage with the authority early to check these points. For example, if a copy of the contract or the heads of terms are shared during pre-market engagement, give some feedback, have a look at the contract, have a look at the terms and feedback, or by raising clarifications during the clarification period in a competition. If you've spotted something in the contract that doesn't work, or there isn't something in the contract that you'd expect to see. So if you're not currently looking at the contract at an early stage, we recommend that you now start to do this. So just briefly going through some of the things on the checklist there, given everything I've said about KPIs, especially in contracts which are over £5 million in value, are these clear? Are these smart KPIs? If they're not, and you're not going to be able to perform against them, that information will now be in the public domain. Reporting, so there may be reporting obligations in the contract which require timely and accurate reports. I can see reporting obligations gearing up in light of all the new requirements. Ensure you've got the systems and processes in place to adhere to those, because a failure to do this in and of itself could be a breach, which could then trigger all of these other consequences, which I've already spoken about. Early warning mechanisms, check if there is one in the contract. And this can be helpful because it can enable you to have a discussion with the authority to find ways around potential problems before they arise at an early stage, and therefore avoid performance issues arising, which then have to be published. Check if there are authority calls, authority dependencies provisions. And the purpose of these clauses is to provide the contractor with relief if a delay or other issue occurs as a result of an act or omission of the customer or the contracting authority. So firstly, check if the contract includes this concept, and if it doesn't, you may wish to raise this. If there are clear roles and responsibilities listed in the contract so that there's no confusion about who is in breach, this should mitigate the likelihood of contractor performance issues arising. I mentioned liquidated damages earlier, and this might require a change in mindset for the construction industry. If your current thinking is it's fairly standard in a construction contract to have LADs, you might now have to consider how relaxed you are about that, as this could give rise to those wider consequences which I talked about earlier in the session. Payment terms, again, that the Act does say, yes, contracting authorities, you have to pay within 30 days, but it doesn't fill in the gaps. So what happens if the payment is late? The contract would have to then fill in the gaps, would have to talk about when interest starts to arise, what the rate is, although there is a concept of statutory interest. It does allow quite a generous credit period for public authorities. So having something in the contract will definitely be helpful to you as a supplier. Rectification plans. Have a look to see if there's a formalised rectification plan process in the contract for addressing poor performance. So if you remember, as discussed earlier, an implied termination right could arise, or a contracting authority could exclude you from procurement if you were given a proper opportunity to improve performance and you failed to do so. The Act doesn't explain what type of evidence or process has to be used. Therefore, in the absence of something which is a formalised written process, this could be highly subjective. So check there's something formal in there. Finally, invoicing. Contracting authorities, as many of you will know, have very specific and onerous invoicing requirements on occasion, and the invoice could be deemed invalid if you don't follow their very specific rules. So in terms of key takeaways, if you don't already do so, as I've mentioned earlier, always check the KPIs first. If the value of the contract is going to exceed 5 million, check you're happy with them. Subjective KPIs, it can work both ways because it's open to interpretation. It might go in your favour, it might not, but it could be a risky approach if the contracting authority's interpretation is more strict than yours. Pre-market engagement, perhaps be more vocal about aspects of the contract that you're not happy with. If the KPIs, for example, being a focus again there, extremely important both for contracting authorities and suppliers to make sure that these are realistic. In terms of supporting contracting authority customers, think about all the data that they're now going to have to collect. Can you help them with that? Could that be a differentiator when you're bidding? That is something that might be a unique offering when you're looking at bidding in public sector processes in the future. In terms of your subcontracts, if you don't already do this, make sure you have 30-day payment terms where you're ultimately subcontracting under a public contract. Your contracting authority customers might ask you to report on that, and that might be a contractual obligation, so make sure that's in there. And then finally, read the contract. You might not get the chance to have an early opportunity to read all of it if time or cost does not allow, but do check those provisions which we just went through on the previous slide and raise those concerns as early as possible because of those problems an authority could have if you leave it till later in the process. Thank you for listening to this bite-sized session today. If you do have any queries, don't hesitate to contact myself or any of my esteemed colleagues on the slide there. And finally, just a quick plug about our Procuring 360 initiative, which is TLT support package for both contracting authorities and public sector suppliers in terms of getting ready for implementation of the new Procurement Act. We are able to offer a wide range of support, not just legal, but also technical, consultancy, and more practical support. So do check out our website or contact a member of the team if you do require any further support in relation to getting ready for implementation of the new Act. Thank you.